Good afternoon, my ladies and lords. Can I first of all say that the Equality and Human Rights Commission is very grateful for the opportunity to make written and oral submissions. Can I secondly, given the Commission's statutory role in relation to protected characteristics across the board, note our observation with pleasure at the composition of the court and the historic event that represents. In terms of our submissions, what you will have seen is that our submissions go entirely to issue 5 as they are set out in the Statement of Facts and Issues, which is the question of whether parents can consent to the confinement of their 16 and 17-year-olds.
Well, that is basically the question.
That is basically the question.
Which all the other questions are indirectly or directly related.
We don't go beyond the narrow confines of that one. And the linked question, or the consequential question, as we see it, or the, which is therefore whether 16 and 17-year-olds who have mental capacity issues are protected by or have the protections of Article 5. We see that as the essential background. In our submissions, we support the official solicitor's overall conclusions. We don't disagree with their reasoning, but as you will have seen, and as I will develop briefly in the next few minutes, we get you there by an additional route, and it's that additional route on which I want to concentrate. As you will have seen, the underpinning of that additional route is a prohibition on discrimination by reference to grounds of disability. So that's the fundamental overarching submission we make. We say the result the OS contends for is necessary to avoid impermissible discrimination in that way. I'll come in due course to talk about various of the points that were dealt with this morning in relation to Gillick and so on, but they are obviously crucial to that. In terms of where that leaves us with what the Court of Appeal said, most of our submissions therefore go to paragraph 143 of the Court of Appeal's judgment. I'm not going to grind you through it in detail, but that's the paragraph in which Lord Justice Mumby dealt with the discrimination argument as it was then put by the Commission in the Court of Appeal. So that's the destination for our submissions. In terms of the first step on the way to that, the question of discrimination, we do draw your attention, perhaps it's worth just turning it up very briefly, to Cheshire West, which is in tab 1 of the bundle of legal materials. It's tab 5 of the bundle of legal materials, page 243. What you see there, and we say this is in some ways the beginning, middle and end of it, is Lady Hale's opening to the discussion section of the judgment. In my view, it is axiomatic that people with disabilities, paragraph 45. It's axiomatic that people with disabilities, both mental and physical, have the same human rights as the rest of the human race. And then 46, those rights include the right to physical liberty, which is guaranteed by Article 5 of the European Convention. You've already had shown to you Lord Kerr's comments in the same case. I don't take you to those. We say, in a way, I don't need to go beyond 45 and 46 for the disability proposition, and indeed we don't understand it to be controversial. Really, everything we've said in our written submission in relation to international law obligations and the unincorporated treaties simply reinforces that fundamental proposition. We say you are entitled to look, and here should look, if necessary, to the unincorporated agreements, which I'll mention in a moment, to establish, we say not necessarily establish, reinforce that proposition. In terms of the reference to the unincorporated international agreements, we don't understand reference to them to be controversial here. The Court of Appeal didn't regard it as controversial, and we don't understand either the respondent or the Secretary of State to regard it as controversial. If necessary, I'll simply draw your attention, if necessary, to what the respondent said. I think it's page 3160. I'll give you the references, 3160. They don't actually dispute reliance on the international agreements for this purpose, and I don't regard that as controversial. You've also had Montgomery referred to you by Mr. Setwright. That's at MS 1539. That's Lord Kerr and Lord Reid looking at international agreements. So we don't regard any of that as controversial. And indeed, in terms of where that then takes us, we don't regard reliance on the UNCRC and the UNCRPD as part of informing this court's evaluation of the common law as being controversial. You have those if you need the detail of them. Well, we've referred in our written submissions to the elements which we rely on. Just to draw your attention to particular elements of that, you have in tab 102 in volume 9, the UNCRC. We would draw your attention in particular to Article 2.1 of that, which makes clear that the rights in the UNCRC apply without discrimination to all children, including those with a disability. And then one of those rights is that arising from Article 37D, which is the question of access to court in relation to confinement. So we say that gives us a clear prohibition on discrimination arising from the UNCRC. You get the same thing more bluntly from the UNCRPD, which you have tab 105 in volume 9, page 2931.
Well, we have problems with the CRPD, don't we?
Well, we say those problems don't arise in this case because we're not here concerned with an issue about the conflict between it and Article 5. We say the same principles arise and there's no reason to disapply the prohibitions on discrimination in a situation whereas here we are not concerned with the potential conflict with Article 5. I would just draw your attention to one limb of it because it is part of the argument against us, which is in relation to Article 4. Article 3, Article 3 sets out the principles of the Convention, one of which is non-discrimination, that's Article 3B, and also Article 3H, respect for the evolving capacities of children with disabilities, and so on. One of the arguments against us, and it features obliquely in the judgment of the Court of Appeal on this point, is in effect an implication that somehow H can trump B. In other words, somehow an implication that evolving capacities can be a basis for what would otherwise be discrimination. We say that's not the case. We also say it doesn't arise in the circumstances of our submission, but in any event we say evolving capacities wouldn't be a justification for what would otherwise be impermissible discrimination. That is an easy route in to the question of discrimination being prohibited in the evolution and understanding of the common law. That immediately gets us into the question of comparator groups or comparator persons. And this really was the essence of Lord Justice Mumby's response to the point as it was put before him, was to say, in effect, to get to the chase, in effect, there is a group of 16 to 17-year-olds who lack Gillick competence, but don't have a disability, but don't satisfy the second limb of the MCA. And he said that because of the existence of that group, and because for that group parents can consent to confinement, there is no discrimination. That, in essence, was the answer on the discrimination point. And I think it's also the answer, as best we get it, from the respondent and the Secretary of State. In order to tackle that, I need to some extent to come back to a question that was raised this morning, which is the interplay between Gillick competence and MCA capacity. Can I first, in relation to that, make a couple of observations on Gillick competence? Can I do so by reference to the case at tab 22 in volume 3, page MS 722, at MS 736. This is Lord Donaldson. As it happens, the case I'm going to go to in a moment is also Lord Donaldson. And it's an important observation, 736, foot of the page by letter H, running to the top of 737. He says 3 lines down, the House of Lords in that case, Gillick, was quite clearly considering the staged development of a normal child. For example, at one age it will be quite incapable of deciding whether or not to consent to a dental examination, let alone treatment. At a later stage it will be quite capable of both, but incapable of deciding whether to consent to more serious treatment. but there is no suggestion that the extent of this competence can fluctuate upon a day-to-day or week-to-week basis. What is really being looked at is an assessment of the mental and emotional age as contrasted with chronological age, but even this test needs to be modified in the case of fluctuating mental disability to take account of that misfortune. We say what you get from that is a clear and we say correct recognition that Gillick competence is developmental. It is not a spot question which varies from day to day or week to week, as Lord Donaldson put it. That matters, we say, when you come, as I will in a moment, to look at the general position of 16 to 17-year-olds. In terms of understanding the general position of 16 to 17-year-olds, the judge looked at a range of statutory provisions which he saw, the judge at first instance, as shedding a direct light on the legal position for 16, 17-year-olds. We don't use them for that purpose. We use them because they shed light on what Parliament has said, or can be taken to have said, about the position of 16 and 17-year-olds and their Gillick competence in relation to the issues in question. And I would draw your attention in that respect to one particular provision and one particular authority. You haven't been taken to this morning because Mr. Setright's submissions focus on the MCA. We draw your attention to the Family Law Reform Act 1969 and the consent to medical treatment position. You have that in tab 2, volume 2, tab 8, at page 322. Three three two. 332 is the section 8. I'm rightly corrected. That is the provision which explains the position of the 16 to 17-year-olds in relation to treatment. Lord Donaldson spoke to that in the Re-W case, which you have in volume 3 of the authorities at page 744. And the passage I'm interested in is at 756, running on to 757, where Lord Donaldson says this of section 8, foot of the page by letter H. The wording of subsection 1 shows quite clearly it's addressed to the legal purpose and legal effect of consent to treatment, namely to prevent such treatment constituting in law a trespass to the person, and that it does so by making the age of consent for a 16 or 17-year-old as effective as if he were of full age. This is the important bit. No question of Gillick competence in common law terms arises. The 16 or 17-year-old is conclusively presumed to be Gillick competent, or alternatively, the test of Gillick competence is bypassed and has no relevance. We say that is right, and we say the same logic which underpins that applies equally here. No reason of principle to think it would not apply here. Nobody's drawn a distinction between the position in relation to medical treatment and confinement for the purpose of their submissions for this court. So
but he's not saying that capacity is irrelevant.
No.
Because Section 8 makes the consent of a 16 and 17-year-old as effective as it would be if they were 18, which must mean that if they lack the capacity to make the decision, then their consent is not effective.
If they lack the mental capacity, then that's exactly the point, my lady. This goes to the question of whether there is a cohort of 16 and 17-year-olds who lack Gillick capacity, but aren't also mentally disabled, if I can use that expression, who also don't satisfy the second limit of the MCA test. So what the 16
you say medical treatment and confinement are to be treated as the same thing?
No, but for the purposes of our analysis, clearly they're not, but for the purpose of understanding the way the common law should approach confinement, we say that the proposition that underpins what Lord Donaldson is saying there, namely that 16, 17-year-olds are taken by the statute to be able to consent because they have the capacity, the Gillick capacity, applies equally here. He is not saying, and we're not saying, that that overrides the MCA. Precisely not. The point is that in that instance and in this instance, the cohort of 16 and 17-year-olds who don't have Gillick capacity because they fall foul, as it were, of the Mental Capacity Act test, because they are in that position because of a mental impairment. So there is no cohort, there is no residual cohort, and this is the critical point, of 16 and 17-year-olds who don't have Gillick capacity, but who are not in that situation for reasons of mental impairment. There are no non-disabled, if I can put it in very crude labelling terms, 16 and 17-year-olds who lack Gillick capacity. That is because the Gillick process is a developmental question, and if you are a 16 and 17-year-old who doesn't have Gillick capacity, that the developmental underpinning of that, we say, is a MCA second limb question. That matters because what that means is that when you then come to do the comparator exercise for the purpose of the discrimination discussion, as per Lord Justice Mumby, there isn't, as he contemplated there might be, a cohort to compare the mentally impaired 16, 17-year-old with who is not mentally impaired. They are one and the same cohort. In terms of what the other parties say on that, neither of them directly address it. It's interesting, neither of them identify who the cohort might be of Gillick non-capacitous, but also not mentally impaired 16, 17-year-olds. Birmingham had identified, had made a nudge to this in their application for permission to this court. It was the vulnerable, the overborn, but they've not maintained that submission in their written case before this court, and the Secretary of State says nothing about it. The closest the Secretary of State's come to it, and this is page 3221, MS 3221, it is a single sentence. It's in paragraph 55 of the Secretary of State's case. Where the Secretary of State say this: not all non-disabled 16 and 17-year-olds will be Gillick competent. Now, assuming we're talking for a moment about, we're limiting our question of disability to mental impairment, not all non-disabled 16 and 17-year-olds will be Gillick competent. So they throw out that proposition, but at no point is that explained or expanded on. At no point is the nature of that cohort identified or clarified. And our simple submission is, unless that cohort exists and is a material cohort, then the disability discrimination point is clearly made out. And the answer to it that was given by Lord Justice Mumby and indeed by the other parties falls away.
But what is meant, do you suppose, by disabled in this context? It's obviously discussing disability as a concept that is in the UN Convention, but what is being meant by disabled?
Well, our inference, and we may be wrong, this is the closest we've found to the Secretaries of State's addressing this point. Our inference is that when they talk about disabled and non-disabled, they are focusing, in the context of this case, on mental impairment, not on, we don't for a minute think they're talking about disability generally. We assume they are talking about a 16 or 17-year-old who doesn't have a mental impairment of an MCA type, and that is the cohort they're therefore describing. And all they say is there will be, if you like, Gillick competent, or not Gillick competent 16 or 17-year-olds who are not disabled. And we say that is effectively a nil class. And we draw your attention, as I say, to what Lord Donaldson says.
It all depends what's meant by disabled.
Well, of course it does, my lady.
If disabled means lacking capacity within the meaning of the Mental Capacity Act, then that's one thing. If it's meaning something completely wider and
my lady,
of course it stands to reason.
Yes, yes. As an unqualified proposition, it's a no-brainer.
Yeah.
We take it to mean something more nuanced because this is their answer to the non-discrimination claim. If it is, in a sense, a wider statement of the absolutely obvious, then it certainly doesn't provide an answer to the point that was made before the Court of Appeal and that we then repeat before this court. And it means that there's not even an attempt at a nod at the class of comparator who would deal with what is otherwise the discrimination problem which arises from the other party's approach and the Court of Appeal's approach.
Of course, if there were two classes, those who lacked capacity and those who lacked competence, but both of them, for whatever reason, were not able to give a valid consent, it's possible that they're both being discriminated against.
That's absolutely right, milady, but the proposition that's come from the other sides, as it were, and from the Court of Appeal, is that the case of the individual who lacks Gillick capacity but isn't disabled for mental impairment reasons, somehow in that instance the parent can consent. So they are the safety valve release, as it were, which provides the answer to the discrimination point in the submission of the other parties. So that's not to say they wouldn't be being discriminated against as well, but it wouldn't be obviously disability discrimination because they are on the face of it not disabled, if that's how you've defined that group. Well,
there will be other statuses that could.
If one is talking about the overborn, and that's the closest we've got to whatever that means, the closest we got to that, my lady, as I say, was in the submissions from the local authority. That's at page 3046 in that bundle. That's in their application for permission to appeal. As I say, not a submission, as far as we've seen, that's repeated in the written case here. Paragraph 15, 5 lines down. It's perfectly possible to think of a 16-year-old without an impairment, stroke disturbance of the mind, stroke brain, who will have capacity, but may still, for example, by reason of lack of maturity, being overborne by the will of a relative or being in love, lack Gillick competence to make a decision. So that's the putative group. We say if it's a question of lack of maturity, then that's likely to be the mental impairment point. If it's the overborne by will of a relative or being in love, then it's hard to see how parental consent could be an answer to that anyway. But that's not part of our case, not a necessary part of our case. And even if there is such a cohort of people, then we agree with the official solicitor's submission. This was paragraph 63 of the official solicitor at page MS 3126, to the effect that the answer to deal with their transient and potentially emergency needs is the inherent jurisdiction of the court. And you were directed, and we would direct you to the Riel case, which is volume 4, tab 42, MS 1414 at paragraph 67, which is the reminder of the inherent jurisdiction to deal with what they're called vulnerable adults. We say the same would apply here. So if, which we doubt, there is that third cohort, that's the answer to their situation. But we don't see it as a third cohort because we don't accept, as I submitted, that there is a cohort who lack Gillick capacity but not for reasons of mental impairment. And we say, in one sense, in terms of our submissions, that's the beginning, middle and end of it, because the axiomatic prohibition on discrimination then underpins or reinforces the common law's recognition, we say, that for the mentally impaired lacking Gillick competence, 16 to 17-year-old, parental consent can't be an answer, because if it were, then that would be discrimination comparing them with the overwhelming majority of the 16, 17-year-old population whose parents can't give consent because there's no dispute about the young person's capacity. There's a question this morning which arises in the middle of that, which is whether there is a distinction between, or what the distinction is between, well, we won't dance on the pinhead of Gillick competence and capacity. We don't think that's a material linguistic question. As between Gillick competence and the MCA test, our submission is that the answer simply is in what the Secretary of State calls a diagnostic test and in the presumption, not in the initial question of whether the young person is able to reach a decision, which we say the common law simply should reflect, if anything, what the MCA says on that point. My lady, unless we can assist further, those are our submissions.
I feel sure you can.
At the
moment, the question I was going to ask you has leapt from my mind. So thank you very much indeed, Mr. Wolf.
How many do you want?
Yes, I've remembered now what I was going to ask you. Sorry, Sir James. Yeah.
As long as I don't need my lecture.
Got another couple of minutes, yeah. You are taking it for granted that if you have a competent stroke capacitous 16 or 17-year-old, it would not be possible for the parents to override their refusal of consent.
Yes. Yeah.
You're taking that for granted, are you? Yes.
Although that's not directly an issue in the case, but we are, yes.
Well, no, it's a rather important way of looking at things in the case. And I believe that Mr. Setright was making the same assumption. I believe he was. His amanuensis is saying so. Well, that's very interesting because it's not uncontroversial, especially in the light of other remarks by Lord Donaldson in those two cases to which you've drawn our attention.
Indeed. And I appreciate I took the passages
Yeah.
out of context necessarily.
Okay. Thank you very much indeed. I'm sorry, Sir James.
Not at all. Ladies, my lord, the Secretaries of State, and there were two formal interveners, and one with an obvious interest in the Health Department, are grateful for the court permitting them to intervene. The issues that this case raises are of obvious importance across the work and responsibilities of all of those departments, and they have implications for a large number of young persons, 16 and 17-year-olds, being cared for in a whole variety of different settings, and the case raises important issues about the nature and extent of parental rights and responsibilities. As my ladies and my lords will be also aware, there is currently a bill going through Parliament, or in the course of being considered by Parliament, in this area. I put it no higher than that, don't make detailed submissions about it, but thought it right that the court should know that that was being considered by Parliament. The procedural position, so far as that is concerned, is set out in paragraph 3 of our case. I don't expand on it. And if you want to look at the draft, it's in bundle 9, tab 98, page 2855, but I wasn't going to turn it up. I was going to concentrate...
Basically, what it is doing is simplifying the procedural safeguards required for a deprivation of liberty.
It is, and it may also be, as you've seen from paragraph 3, that Parliament will be considering the merits, demerits and nature of any definition of deprivation of liberty.
Well, they may be doing that, yes.
But my lady is right.
Currently, it's tied to the Strasbourg definition.
It is.
That's the reason for the safeguards, so one wonders, what scope there is. But the point I'm getting at is it simplifies the safeguards. It applies the safeguards to all kinds of living arrangements, not just to care homes and hospitals, but it continues to apply only to the 18-pluses.
It does.
But it would be, in the event, and I'm not suggesting anyway, one way or the other, that the Secretaries of State's view was not to prevail, it would not be too difficult to promote an amendment to the bill which applied the safeguards to 16 and 17-year-olds, thus giving a safeguard without the need to go to court in every case.
My lady, that's possible. I mean, of course, any amendment can be promoted if there is the will and if there is the majority and if there is no other business in its way.
Well, yes.
But my lady is right. My lady, I was going to address my submissions in the very short period that I have, mercifully, to two things, one much shorter than the other. The first one is stalk component A in a case involving a child or young person. That's the objective component, is there confinement. It doesn't arise on the facts, given that all sides were agreed and are agreed that there was confinement on the facts. I make no submissions about that. But there are important issues raised about the role of parental responsibility in that analysis. Is the official solicitor right about Nielsen being a category A case rather than a category B case, if that makes sense? And there is also an important measure, it's to be noted, of common ground about the key issue which may arise under this head, which is whether the acid test laid down in Cheshire West should be subject to some nuancing or modification in the context of children or young people and or young people. And my submission is that a child or young person is only confined, so only satisfies stalk component A, if first the acid test is met, in other words, under complete supervision and control of those caring for him or her, and not free to leave the place where they are living. And, as an additional question, the restrictions go beyond those that would be likely to be imposed on a child of the same age and relative maturity who is free from disability.
And you've thought of some more examples apart from detention in school, have you?
I haven't thought of many more examples of detention in school, and you'll appreciate that in my capacity of trying to represent the Secretaries of State here, there is the broader concern that if principles are laid down in a case such as this, they as it were, spread outside the immediate factual context. I quite see the force of the point which I think underlies my lady's question, and acknowledge that in the context of 16 and 17-year-olds, if you're doing that comparative exercise, you're a great deal less likely to bump into equivalent restrictions than you would be in the case of very much younger children. So the real point I seek to make under this first head of the submissions is that modification or nuancing is in principle a good thing. It may well be that its practical application, the practical application of the modification principle tapers away as the child moves up the age range. And it might be thought to be no accident that when when Lord Justice Mumby, but sitting at first instance, came back to this issue in the AF case, to which I'll come, and was invited to say, well, are there particular age ranges where this is going to be a truly interesting issue? Will you give some guidance? Can you set down some general principles about age ranges where this is going to be really interesting for the purpose of the comparison? He was thinking about age ranges of, I think, 10 to 12, it turned out. So, but I quite accept the force of the point that my lady puts. Nevertheless, there may be some circumstance in the context of 16 and 17-year-olds. And the critical thing, it might be thought, is that if one is in this territory, it may be important for the court to acknowledge that in principle, that sort of exercise is the correct one, whatever the practical scope of its application. We also invite the court to acknowledge, and I think this may be less controversial, if controversial at all, that there is running through all of the analysis on confinement under deprivation of liberty in Article 5, questions about whether or not restrictions that are in fact imposed on children or young people amount in truth to no more than restrictions on movement as compared to true restrictions on liberty. There is that well-established distinction in the Convention between Article 5, which deals with deprivations of liberty, and Article 2 of Protocol 4, brackets to which the UK has not yet signed up, which deals with freedom of movement. I don't develop that because it's not central to the issues on this appeal, but it's an important principle to be acknowledged nonetheless. So the submissions in support of the principle of nuancing or modification in the context of children or young people, why do we respectfully submit that that is the correct approach in principle? First, because it is supported by authority, and second, because it's a good idea in principle, we submit. So far as authority is concerned, Nielsen you are well aware of, Bundle 1, Tab 6, MS 262, it's the first page, and the key passages for this purpose, in other words, the approach of the European Court, which did involve precisely that sort of comparative exercise, the modification or the nuancing, if you will, but the comparative exercise that lay at the heart of it. The key paragraphs for that purpose are 70 on page 281 in the MS numbering, and the relevant subparagraph, it's the third subparagraph in the middle of the page, beginning the restrictions on the applicant's freedom of movement. Just that third subparagraph. 72 on page 282 and for this purpose it's the second, or the last third perhaps, of the second sub-paragraph, if that isn't too complicated. So the sub-paragraph beginning the restrictions imposed, if you track about 7 lines down, there's a sentence beginning, indeed, the restrictions to which the applicant. It's that bit. And then the same theme one sees also in 61. And the European Court has consistently recognised, both in Nielsen and in cases that have followed Nielsen, that parental rights, which are themselves protected under Article 8 of the Convention, can and do involve parents deciding where a child should reside and imposing various restrictions on liberty, suggesting that allowance can and should be made for that. I'm simply on the support for the modification or nuancing of the Article 5 acid test.
So are there other cases than Nielsen
There are
which
other...
say that parents can lock their children up or consent to their being locked up?
Well, my lady, the cases I was going to take you to were, first of all, Osman and Denmark, in the slightly different context of immigration, and that is in Bundle 7, tab 79. I'm going to come to the consent issues in due course. That's going to be the second limb of my submissions. I'm simply at the moment on confinement.
Yes.
And whether a comparative exercise is a good idea or not. But one sees in Osman and Denmark, at Bundle 7, tab 79, MS 2559, paragraph 64, which I think sets out the principle as I've just described it. So 2559, para 64, top of the page, emphasising the fundamental element of family life, which is parental rights, care and upbringing, what it involves, restrictions on the child's liberty. And you see the citation at footnote 4. Nielsen, para 61, and this, of course, is 2015, if you look at page 2545. So that's Osman and Denmark, and in the same bundle and to the same effect with the same principle, shortly after Nielsen, Family T, behind tab 69, and the page for present purposes is 2238. So this is the Commission in 1989. Nielsen was November 1988, so this is a year after Nielsen, and they basically replicate that, set out that principle, page 2238, in the first full paragraph under the title in the bottom third of the page of the law. So the paragraph which starts, while the protection afforded by this provision also covers minors, has to be noted at the outset, and so on. So those are two Strasbourg authorities post-Nielsen supporting the comparative approach.
Yes, but that refers to restrictions on liberty without there being a deprivation of liberty.
That's true. It's a different context, as I acknowledge.
Yes, and Osman is obviously also referring to restrictions rather than deprivation.
It is. So one has, if this is the purport of my lady's question, one has Nielsen, as it were, as the confinement case, which is no doubt why it's controversial.
Oh, it was controversial at the time, let alone.
And 9/7, as I know my lady will be well aware.
I mean, we ought to bear in mind. I'm not sure how much should we bear in mind the fact that the majority of the court was disagreeing with the Commission in Nielsen, and the court was 7-9, I think.
Well, my lady,
Including, I think, Judge Spielman in the minority.
You can take it into account, but
Yeah.
sometimes this court splits 3-2 and disagrees with all the courts below.
This does happen, yes.
They haven't got a formal doctrine of precedent, but it is a court decision, and it's a court decision that has, in relevant parts, as far as we're concerned, for this principle, been applied subsequently. That's the point I make. And you get to similar effect, this comparative approach, comparing them with the restrictions that might be imposed on children in the ordinary run of the community. You get the same point in the domestic case law, most notably in Cheshire West, Lord Kerr, paras 77 to 79. I'm not going to go back to it, page 251, bundle 1, tab 5. And I think my Lady Hale at paragraph 47, acknowledging the good sense of that sort of comparative exercise. One sees it also for good measure in Lord Justice Judge, as he then was.
Well, we were, of course, using it in the reverse sense.
You were. You were.
Both of us.
you were. But nevertheless, I think Lord Justice Judge in K was using it much closer to the sense that I am. Again, I'm not going to invite you to turn it up, but if you go back to Ray K for that comparative approach, lots of parents restrict children in these ways in the community. It's bundle 3, tab 27, page 860, at page 19, at paragraph 99, on page 890, that's Lord Justice Judge, and Lord Justice Thorpe, to similar effect, paragraph 53 on 879. And all of those cases were ultimately relied upon for this comparative approach, so as in effect to create the binding authority that he couldn't create in this case by Lord Justice Mumby sitting at first instance in the AF case, to which I referred earlier on. And that, it may just be worth showing you briefly, without inviting you to read large chunks of it. 6. Tab 63, sorry to jump around between the bundles, starts at electronic 2085, and the relevant part of the analysis for this purpose on the do you do the comparison is paragraph 14 all the way through to paragraph 44.
Sorry, could you just give me a page reference, MS reference?
Yeah, MS reference for the start of paragraph 14, where he starts with the analysis of Cheshire West and my lady's judgment there, 2091.
2091, thank you.
For paras 14 to 44. But at some point, if you want the detailed analysis of and support from Sir James Mumby for that comparative approach, it's there. And if you wanted an authority in which that has then been worked through in action in the context of a 14-year-old, there's quite a helpful illustration of the principle working in the judgment of Mr. Justice Cobb, recent judgment of Mr. Justice Cobb, bundle 6, tab 65, electronic 2119, and it's a case called RD. But you can see the analysis there being worked through. It's paragraphs 36 and following. Wanted to see how that principle works in practice. That's a good illustration of it.
But could one go so far as to say that if there is a restriction on liberty, including a loss of liberty, on a child which is lawful under the national law, the domestic law, it will not be a deprivation of liberty within the meaning of Article 5?
I think one could go that far. It does involve doing the comparative exercise. I suspect that when this principle, if it's adopted by this court, is worked through by the lower courts in the practical examples that will then arise, the difficult questions are going to surround precisely how you analyse the comparator group.
Absolutely.
Is it the most strict parent you can imagine? Well, no one, I think, is espousing that. Or is it, are these the sorts of things that you would expect parents to be doing?
The case of Austin, on very different facts,
yes,
is indicating that that is so, isn't it?
Yes, it is. That's the Kettling case. My lady's right. So that's what we say about authority in the comparative approach. In terms of the appropriateness of that in principle, but we respectfully submit that it is right to recognise that restrictions should be approached differently between adults and children. That's right precisely because children are children, and parents have a role and responsibilities and rights in regard to them. And the analysis in essence is that modification is needed to the concept of confinement to take account of that special position of children and that special position of parents in their upbringing. So in practical terms, if one treats if I'm considering the position of very young children, all young children are under continuous supervision and control and not free to leave. If they sought to run away, they'd be brought back or they'd be placed into care. But it isn't confined to that. And although there may be less scope for its practical application in the context of 16 and 17-year-olds, the principle is an important one. Can I turn then to the subjective element and parental responsibility? I'm going to have to go quite quickly over quite a lot of ground in relation to this in the time that remains, but we essentially invite the court to consider four submissions under that heading. So I'm now on Stalk Condition B, the subjective element, parental responsibility, and how all that works. And we start, before getting to the submissions, with an acknowledgement, as we've seen from some of the case law already, that the Convention itself does recognise and respect parents and parental rights as decision makers. It's a fundamental part or aspect of family life under Article 8, as the Convention recognised. That doesn't, of course, answer the question about limits, but that right is recognised is plain and important, because ultimately this court is going to have to grapple with the balances that might be thought to exist or might need to exist between parents as decision maker, after advice perhaps, with no doubt the best interests of their children at heart, and the various other rights that are in this place. But that there is a difference, and that parents would perceive there as being a real distinction between, on the one hand, being consulted, and on the other hand, it being their decision about their child, subject only to the controls that the law necessarily imposes about best interests. That is a real distinction, is important, I respectfully submit, and should feed into this court's analysis, but it finds an echo in Article 8 and the recognition of those rights as an integral and fundamental part of Article 8. So to the four submissions, firstly, we submit that Nielsen, which we've already looked at, indicates that consent can be provided under the Convention by those who have parental rights and responsibilities. It is a case, that is, Nielsen is a case, which considered and turned on this issue of consent. So it can't be avoided, that feature of it can't be avoided by suggesting that it was only to do with what became Stalk Lim A, ultimately, in other words, confinement, because that isn't the analysis of the European Court of Human Rights. And I'm sure you'll all have read it more than once, so I don't need to go back to it, but one sees that from paragraph 61, an acknowledgement that parental rights are protected as a fundamental element of family life, we saw that. On the facts, the decision to have the applicant hospitalised was, as they put it in 61, a lawful exercise of parental powers under Danish law. And see paragraph 73, to which my Lord Lloyd Jones drew attention this morning, for the key conclusion, which also indicates that it's a parent's about exercise of parental rights. Of course, as Strasbourg recognised, there are limits. The interests of the child sit alongside those parental rights and are not excluded by them. Hence the analysis of Strasbourg between 68 and 72 of the medical advice, the approval by social services in Denmark, and so on. There were plenty of things that Strasbourg looked at to make sure that this wasn't arbitrary parental consent. So Strasbourg in Nielsen, properly analysed, is precisely about that issue and demonstrates that consent can, in principle, be provided by those who have parental rights and responsibilities. And I emphasise this is consent to things which are confinement, because the Cheshire West three-stage analysis involves three cumulative conditions that must be satisfied. They've all got to be satisfied. So you only get to consent if it's already confinement. But this case, that is Nielsen, is a case centrally about consent from the parents to confinement, that that's the correct analysis of it is, we respectfully submit, confirmed by my Lady Hale's analysis in Cheshire West, analysing it in precisely that way, as a case about, I think as my lady put it, substituted consent, that is the parent for the child. See paragraphs 30 and 41 of Cheshire West. And Nielsen has not been departed from or questioned since. Indeed, it continues to be cited by the Strasbourg court as a case which turned on, as it was put in subsequent cases, quote, the responsible exercise by the applicant's mother of her custodial rights. I take that from the European Commission case of Koniarski, Koniarski, against the United Kingdom, Bundle 7, Tab 70, MS 2244, and in the same terms by the European Court in DG and Ireland, Bundle 7, Tab 71, 2269, and the paragraph is 72. So we respectfully submit that the Court of Appeal's analysis in this case, that consent can be provided by those who have parental rights and responsibilities, is and was correct. That's the first proposition. Second proposition is that at common law, the position as to the relevant nature of parental rights and responsibilities is well established. And Gillick is the leading authority. I'm not going to go back to Gillick. We've set out the core propositions that we say are to be derived from it in our case at paragraph 39. In summary, it established that for all the reasons that were given by the majority, and this was the area of disagreement amongst their lordships in that case, that but for all the reasons given by the majority, there are no hard age lines, or as the Court of Appeal put it in our case at paragraph 79, there is no rule that the age of discretion is fixed. So the question, if and when a child is competent to make decisions, is an individual one depending upon understanding. You don't suddenly trip to understanding and competence. It's an individualized question depending upon the understanding and the maturity of the young person in question. That case also emphasised, as my learned friend Mr. Setright pointed to this morning, and we don't dissent from this, that parental rights have got to be exercised in the best interests of the child. They are not, in Lord Scarman's words, treated as sovereign or beyond review and control. But they do, and it's important to recognise this, sit alongside that position dwindling as the child or young person's understanding and competence increases, but they're still in play until adulthood. So subject to the child itself being able to make the decision, applying that test, there is still a role and a balance, a role for parental rights to be exercised under the common law up until 18. And so again, we respectfully submit that the Court of Appeal's analysis of the common law, in our case, paras 51 and following, and especially its analysis of Gillick at 70 to 85, was accurate. Thirdly, third proposition, there is nothing, we respectfully submit, in the MCA to suggest that it was intended to override that common law position and those continuing but dwindling parental rights. Or put another way, to replace the common law with an exclusive framework based on a child reaching the age of 16. And there's nothing in the MCA to suggest that for four reasons. Firstly, such a significant change, such a significant narrowing or abrogation of the common law and the household law's authority that will have been well known to the legislator could be expected to be clearly made, if it was going to be made, in the MCA, given in particular that it would involve a serious alteration to previous parental rights. There's nothing in the MCA itself to so indicate, and nothing to make provision for ambit or extent, still less exclusion of parental responsibility. And there are
Is there anything
provisions.
in the Law Commission's report?
My lady, we've cited the Law Commission's reports. There are various Law Commission's reports that preceded.
Yes, but the one which led to the Mental Capacity Act was 231, I believe.
Well, I think that contemplated, as we set out in our case, the possibility of parallel regimes continuing to exist.
I can't remember, that's why.
Yeah, but I think the answer to that is we did try and analyse. It may well be that my lady's
We may have said
recollection
nothing of any
understanding
help at all. We may have been extremely...
No, well, can I just give you the paragraph, given
Yeah.
the time?
Yes.
It's 46 in our case, where we've sought at least to assist in that respect.
Yes, that was about the overlap of jurisdictions. That's what I was thought, and the Act does provide for that because it provides for a transfer of cases between the two. Not sure that it deals with the
particular issue.
the particular issue with which we're concerned. I couldn't recall that we had done, but
No,
it's
but
a long time ago.
yeah, well, my lady, I'm not going to seek to make submissions about that area to you. But nothing in the Act itself is the first of the points under this heading. And by contrast, there are other provisions elsewhere in the statutory framework which do make specific provision altering the common law position relating to consent by parents. The classic example, perhaps, is Section 131 of the Mental Health Act 1983, which we've referred to in our case at paragraph 50 sub 2. And if you want it in the raw, Section 131 is in volume 2, tab 9, MS 333. But that is a factor which, if anything, indicates that if Parliament was intending to alter that so as to render the child after 16 able solely and exclusively to consent, it would have said so, because that's what it did in that other legislation.
I think I'm right in thinking that Section 131 of the Mental Health Act is like Section 8 of the Family Law Reform Act,
Similar.
in that it validates consent and doesn't say anything about dissent.
Well, I thought 1314 maybe thought to go a little further, but so it's
Well, if there is something that does, that would be helpful.
MS 333, bundle 2, tab 9. So 1312, you see,
Yes.
16 and 17-year-olds with capacity to consent to making the arrangements. 3 is dealing with if the patient consents. And then 4, if the patient does not consent to the making
Right.
of the arrangements.
Subsection 4 actually deals with the issue.
Yeah.
Right. Thank you.
That's, and you understand why I take you to that in this context, because it's as it were a bolster to the point that the MCA doesn't deal with it. This is an act which preceded it, and where they wanted to interfere with the common law rights in that way, they did so very clearly, and they did so expressly.
And they may not have thought they were interfering with common law rights. They may just have thought that they were clarifying what had previously not been clear.
That may very well be right, but the significance of the point is the express wording when they do it, whatever the motivation behind it. Secondly, as to why there's nothing in the MCA to suggest that, and it would be surprising if it did, it would be all the more surprising that the MCA doesn't deal with this at all, for the reasons given by the Court of Appeal below in paragraph 125, and that is in essence because, that's at page 3278, because the exercise of parental responsibility continues but dwindles based precisely upon the maturity and understanding of the child. And that was the fundamental principle established by Gillick. There isn't any sharp distinction or exclusion from a set age, and the concern that that approach of drawing a sharp distinction would be, in effect, a reversion to the much more hard-edged approach that had preceded Gillick. It was precisely that which the majority found objectionable in Gillick. All the more reason, therefore, if Parliament was going to alter that position, for it to do it clearly. Thirdly, and again, I've taken you to the bits of the case which started with the Law Commission's reports and went on to deal with the relevant parliamentary materials, but not obviously as important as the first of the points I've made. The pre-legislative context and the debates provide, to put it negatively, no support for the case that it was intended to be an exclusive regime and to cut out the previous role for parental rights and consent. On the contrary, if anything, the intention or the understanding appears to have been that the regimes would continue in parallel, our case at 46 to 49. Fourthly, because there is no reason to make the change, for Parliament to have made the change, especially because the law does provide for protections over the exercise of parental consent. The law can and does protect the child or a young person in the manner envisaged by the ECHR case law. But specifically, the person with parental responsibility who is considering consenting to confinement or is consenting to confinement must be acting in the best interests of the child and for the proper purpose of exercising parental rights in that way.
And how is that enforced?
Well, the court can intervene to provide...
Which court, on whose application?
Well, this is dealt with, my lady, in Gillick at 200B to E, acknowledging that the court can intervene. We've set out the other safeguards in our case at 62 to 69. I won't be able to go through them all, but you will have seen that they include, in particular, first of all, the interposition of professional advice before consent to confinement is given. And we respectfully submit that that would be a legitimate requirement for the common law to impose under Gillick. And if that is so, the professional will then be engaged in the case, and if it considers that parental consent is not in the best interest of the child, can raise it. And in many of these cases, you will have the local authority or the local authorities involved under the Children Act with all of the safeguards we've set out in that Act, including periodic and independent reviews, the independent reviewing officer, and so on. So we do not accept that there is some form of fundamental, as it were, protectional deficit if you are to acknowledge the sort of role that the common law would continue to provide under Gillick to parents.
Every single one of those safeguards applied to informal patients in the Bournemouth situation, but that was held not to be enough. What was required was contemporaneous or near contemporaneous safeguards, rather than the sort of ad hoc ex post facto safeguards that you're talking about.
Is my lady referring to Staffordshire? The Staffordshire case?
No, I'm not referring to Staffordshire. I'm referring to the fact that before the Bournemouth case, informal patients who lacked capacity could be admitted to hospital without any procedural formalities or any automatic reference to a court to check whether they should be being confined, and yet that would almost invariably involve medical advice, subsequent reviews by at least the hospital, and sometimes other types of Care Quality Commission type reviews, and so on. But Strasbourg held that that wasn't enough.
Because they were ex post facto, in a nutshell.
Because they were ex post facto and required triggers.
But my lady, I come back to it, if I may respectfully do so, that there is ultimately a balance here to be struck in relation to the 16 and 17-year-olds. We're on that divide between MCA and common law, and the extent to which common law can simply drag in processes, procedures, specific tests from legislation. That's constitutionally problematic for obvious reasons.
And we are hampered in discussing these issues by the undoubted fact that in this case the parents have been acting very much in the best interests of D, and everybody accepts that, and you've got the best of intentions all round.
Of course.
But the law and safeguards are safeguards against not the best of intentions.
That I totally understand. and if I may respectfully say so, agree with. Yeah. But that's why when we were dealing with the safeguards in that latter part, that latter section of our case, we sought to set out the various safeguards that could and would apply. And I respectfully submit that when those are taken in their totality, they do not exhibit the vice that my lady is talking about.
What about the 17-year-old who hasn't hitherto been in local authority care?
Well, if the position is that, assume for the sake of argument that you adopt our suggested safeguards, that will include seeking professional advice and assistance before that consent is given.
But what if they don't?
Well, then...
Or what if the professional is also misguided?
Or corrupt? Or has a private financial interest in admitting the child to his own facility? The whole of the Mental Health Act is designed to protect patients from just that situation.
Well, my lady, in deal with the situations. In the local authority situation, you have all the panoply of independent reviews and people being engaged in the actual decisions that are being made on behalf of the child. So the problem doesn't arise there. We recognise that if you just simply left it to the parents and they were outside that situation, which may be a pretty rare case, then some form of further protection is needed. And the involvement, and it's for the court to say what sort of involvement, but if the involvement is does involve someone who is professional, then of course any system is subject to abuse, but the involvement of that professional should and does act, I respectfully submit, as a proper safeguard to ensure that if the parents are misguided, that is drawn to the attention of the relevant authorities and or the court if necessary. Because otherwise one simply, as it were, removes for 16 and 17-year-olds, you drop the adult age down to 16. You remove the capacity for the parents to consent. And if the common law is striving to balance these interests, I respectfully submit that it should strive hard not to get to a place where this cannot be done, where the parents cannot consent to action which they regard as being in the best interests of their child, even if it does involve confinement. And of course, confinement can cover a whole range of, quite a broad range of circumstances, especially following Cheshire West. But it's a big step to cut them out of that process. And we respectfully submit, therefore, that the court should be astute to try to resolve and to identify safeguards that are sufficient, certainly, to protect, because the best interests of the child are there to be protected and are paramount.
Can I just stick with the 17-year-old who's not in local authority care when confined? It's brought to the attention of the authorities that this is not a good idea. What action is taken?
Well, my lord, my lady, the professional could presumably take steps then to bring matters either to the attention of the relevant local authority or...
And what does the local authority do? You can't make an application for a care order for a child who is either married at 16 or 17 years old and unmarried.
One could apply to the court under its inherent jurisdiction, could one not, to raise an issue concerning whether or not someone was consenting to or taking action that wasn't in the best interest.
Your submission is that that would be acceptable, notwithstanding the cut-off in the statutory scheme of the Children Act.
Malik, I'm just being whispered to. Can I see if I can give you a better answer than one? I think it's being pointed out to me that the inherent jurisdiction cuts in when there isn't an alternative mechanism for raising the matter before the court, when there aren't other safeguarding schemes in play. But if the court can engage with best interest issues under that jurisdiction, faute de mieux, then it can. As I say, I come back to it. Ultimately, this is it's a question about balance, and what would be fundamentally inaccurate, I respectfully submit, is to approach these issues on the basis that if you leave it to the parents, you're effectively just leaving it to the parents, and there is some fundamental deficit. There may be limits to how far the common law can go in adopting what you regard as being sufficient safeguards. And we would be deeply concerned at the level of general principle about the idea that this court could, as it were, simply adopt wholesale a statutory scheme under the common law because it thought it was a good idea. That issue arose in the context of Section 3 of the HRA in cases like S minor, testing the limits of that. No, you can't do that because you're effectively legislating. But subject to that, there is flexibility in the common law to set out the nature of the safeguards that should accompany the acknowledgement and respect for those parental rights. And if that, I'm sorry.
This is probably a very silly question, but why is it an amendment to the common law? Why isn't it saying that the Mental Capacity Act covers these people and at the moment as it stands requires a court application?
Because what the question we are debating is whether or not that is an exclusive regime. Can you do it no other way? And the MCA regime takes the decision-making power, subject to the controls that exist upon that decision, from the parents. That's the difference. So MCA is not about and does not involve parental decision-making about what the best interests of their children are. It places that decision-making capacity into the hands of local authorities and all the courts. Now, it may well be that you end up there, on my analysis, through a different route if there is disagreement. But that is because the parent's decision is not sovereign.
So you've got two stages. The parents decide first, and if they get it, somebody considers badly wrong, then it goes
yes, and that's
on your analysis.
Yes, that's why we were concerned for the common law to take the tolerably small step, not of incorporating wholesale the MCA, but saying before you can give valid consent as a parent as a matter of common law, you need to have engaged with the professionals. And of course, professionals could be corrupt and hopeless and all the rest of it, but that at least is a safeguard so that someone is there, leaving aside the local authority position, someone is there to ring the bell if it goes wrong. But at least under that system, you are striking the balance in a way that allows the parental decision to be controlled in the way it should be, because we agree with Mr. Setright that parental consent must be given in the best interest of the child. You allow for that to be done, but you leave the decision-making with them. And that is important, because it isn't only the child's rights that are involved, and there is a major distinction, we respectfully submit, and would be perceived to be a major distinction between a parent simply being consulted, formally or otherwise, which is the MCA position, about what is in the best interest of their child, and a parent thinking, well, it's my decision. It's my decision, but if I get it wrong and I'm way outside the bounds, it couldn't be the best interest, then that can be controlled. That's absolutely right and proper. So it's about striking that balance. And we do not, with the greatest respect to Mr. Setright in this respect, we do not confuse deprivation analysis with doing the right thing. The reason that we're into safeguards for the purpose of seeking to persuade the court that parental rights should be given that respect is precisely because parental consent is already trammelled with that necessary protection of the best interests of the child. And precisely because if there were a fundamental protectional deficit in simply allowing the parent to consent on any arbitrary basis, that would be a powerful factor against my argument. So it is a necessary and integral part of my argument that the best interests of the child should be properly protected, even if you allow the parental consent to run. And my respectful submission is that those protections on an Article 5 adequate basis do exist. And if and to the extent that they don't, they can be tweaked in a way which doesn't do constitutional damage by dragging across a great statutory scheme. It allows the court to set the alarm bell early.
I thought your argument was that Article 5 didn't apply.
Well, Article 5 doesn't, but we've seen in the analysis of the court in Strasbourg, in Nielsen, that they do consider that there are constraints on the concept of, as they put it, the exercise of custodial rights by the parent.
Well, they do, indeed. But your argument is Article 5 doesn't apply. Because if Article 5 did apply, the requirements of Article 5 would have to be complied with.
Well, my argument is directed to analysing whether or not parental consent has any role to play in circumstances where there is confinement. If it does have a role to play, what are the proper limits to be put upon it? That's all part of the initial analysis under 5.1 as analysed in Cheshire West.
But it must be part of your argument that the safeguards required by HL and the United Kingdom and Article 5.4 don't apply. That must be part of your argument.
Well, they don't need to apply because Article 5.1 is not, Article 5 is not engaged, so they don't arrive.
There we are, you see.
Yeah.
That's what I thought you were saying.
Yeah, well,
Isn't that what he's saying? I thought he was saying that Article 5 doesn't apply.
I am saying Article 5 doesn't apply, and we're out trying to analyse how the various stages in that analysis from Cheshire West, confinement, consent, imputable
Well,
to the state.
I put to you a few minutes ago that you were arguing that Article 5 didn't apply because of something you'd said a few minutes before that, and you seemed reluctant to agree with me on that.
No, that is the thrust of the argument. That is the thrust of the argument, but under the second limb of consent, having regard to Nielsen, consent is not a concept which is absolute and arbitrary and sovereign, if you will. There are controls upon it.
Sorry, I've been trying to just clarify one point. I know you're over your time. In paragraph 58 onwards, which means the safeguards, is obviously a very important section.
Yes.
63 and the professional advice. You simply say the parent must seek and obtain professional advice. I wasn't clear, you don't give any reference to that. Is that derived from Gillick, or where does that come from?
That's derived from Nielsen in Strasbourg, where they had a regard to precisely that the mother had taken professional advice, and it's derived from Lord Scarman, 184G of Gillick.
I see.
And if it wasn't derived from either of those places, it would be legitimate for you to make it up under the common
Yes,
law.
so I see. It sort of steps from
Yes.
And this is,
Nielsen and Gillick. Yeah.
if I could just follow that on, if I may. This goes back to the point about Austin, isn't it? And that is the lawful exercise of a power of restriction of liberty under domestic law will not constitute a deprivation of liberty at all for the purposes of Article 5. But the key, as you responded to me, is whether it's lawful. And it must have all the safeguards in it, as the analysis in Nielsen shows.
Yes, it must have sufficient safeguards, including those. So
And if I could add a follow-on, when we're looking at indications in the Act, would you also say we should look at the fact that Schedule A1, administrative restrictions, it's Schedule A1 to the MCA, does not apply to this particular age group?
it doesn't.
And that is potentially an indication?
Potentially an indication. I'm sorry, I'm over time. And I
Sorry.
You're
apologise
way
for
over
that.
time, yes, and it's our fault because we've been
No,
putting all
but
the questions that no doubt we ought to be putting to Mr. Gordon to you.
He's now had lots of fair warning, so I hope you won't mind if I've been a little bit over. I want us to cover one final thing, which is one final area which will take 2 minutes, which is that there is nothing we respectfully submit in the international conventions that leads to any other conclusion than the one we advocate. I'm not going to make submissions because you'll be so familiar with them about incorporation of treaties into domestic law and all of that. Of course, it's legitimate in interpreting ECHR rights as a source to inform the development of common law, but careful with that because BRIND exists, you can't do backdoor incorporation, and in interpreting ambiguous legislation if you get to that point, but it has to be ambiguous. The only point to invite you to consider when and if you do have regard to those conventions, is the salutary message, as we respectfully submit, in paragraph 62 of the Court of Appeal's judgments in Davey, D-A-V-E-Y, I'm not going to turn it up now, para 62, bundle 6, tab 60, MS 2042, and the basic message was be a bit careful before moving from very generally expressed, for understandable reasons, provisions in international treaties down to something very specific, because those rights, even if they're not expressed in aspirational terms, tend to be expressed at a very high level of generality and therefore are less likely to assist when you're dealing with a very concrete and a very specific issue And that is precisely the position here we respectfully submit. Even if you can take into account all of those conventions, the rights are and obligations are expressed at a level of generality which really does not assist, we respectfully submit, in answering the very specific questions that arise before this court. The difficult balance is precisely how domestic law can and should be set up. And finally, so far as the UNCRC is concerned, the Convention on the Rights of the Child, we do respectfully submit that the three key points coming out of the UNCRC were correctly summarised by the Court of Appeal at paragraph 137 in their judgment. My ladies and my lords, with thanks again for the indulgence and sorry to have overrun. Can I hand over?
Well, your apology is entirely due to Mr. Gordon rather than to us.
I'm sure he will take it from me.
And it's mostly our fault, as I said. Thank you very much indeed, Sir James.
My lady, I'm so sorry. I hope the message got through that
Yes.
I'm going to leave you in the...
Yes, yes. And Mr. Wolfe is going to do the same, so you're in good company.
Thank you. Sorry, we're going to shuffle. That's all right.
My ladies and my lord, as so often, Sir James has taken most of the words out of my mouth, but I will endeavour to reconstruct.
You're usually on the other side, Mr. Gordon.
Well, that's the problem. Subject to the court's approval, my submissions will comprise 4 stages. First of all, I want to make some general observations about the nature and structure of the appellant's case. Secondly, I will state 7 core propositions for which we contend. Thirdly, I will develop each of those propositions in turn. And finally, I will deal with consequential matters. The first point about the nature of the appellant's case, as developed this morning by Mr. Setright, is that it contradicts what was said to be its primary case in its printed case. At paragraph 54.3, the appellant stated, by way of submission, that the MCA contains, and I quote, a complete decision-making framework in relation to the delivery of care and treatment to those aged 16 and above with impaired capacity. That was the primary submission, but it has been replaced by a different submission, which is that despite Parliament, now by concession, not abrogating parental responsibility in relation to confinement for care and treatment within the MCA regime, the common law should be adjusted in policy terms and from first principles to achieve that result. And that reveals a fundamental contradiction between the way in which the case was put in the printed case and the way it's now put. To be fair to the appellant, at paragraph 4 of the printed case, it was also contended that it was an accumulation of domestic statutes that has the effect of ousting parental responsibility in this area. But we say that the contention that the MCA provides a complete framework for the delivery and care and treatment is in fundamental tension with that second proposition. Moreover, the appellant's case, as developed orally this morning, was silent about the way in which the accumulation of statutory regimes was said to oust parental responsibility. It was a disguised plea for the court to legislate, and echoing the submissions made by Sir James Eadie earlier this afternoon, we respectfully submit that that is not a task that this court can legitimately undertake. There is a difference between clarification in certain areas of the common law, such as perhaps, for example, the ascertainment of professional advice before taking action, before giving consent. But that, in a way, is all wrapped up with our concern that the court does not confuse the nature of a valid parental consent operating lawfully with a whole series of changes to the common law which have the effect of bringing in by the back door the Mental Capacity Act regime, which indeed is the alternative case that the appellant postulates. If I can't get in by the front door, in other words, if the MCA does not contain a complete statutory regime, I get in with an alternative case, use Section 4, and bring in the whole baggage of statutory machinery. So we say that in order to succeed in this case, properly analysed, the other arguments of the appellant, the reference to other statutes, the reference to international instruments, takes the analysis nowhere unless it can be established that the MCA contains a complete decision-making regime. The problem with that, as the central submission, is that it ignores the pivotal function of parental responsibility, as to which the MCA is largely silent. In a context where, one, a child of 16 to 17 lacks Gillick competence to consent to his or her confinement, and two, in the exercise of parental responsibility, a parent gives valid consent on the child's behalf. At paragraph 13 of our case, we refer to the importance the courts have always placed on the right to respect for private and family life and in respect of parental responsibility. And the case of Re-HB, Authorities Volume 5, Tab 46, at paragraph 72, but it's cited in our case at paragraph 13, parental responsibility is more, much more, than a mere lawyer's concept or a principle of law. It is a fundamentally important reflection of the realities of the human condition, of the very essence of the relationship between parent and child. Parental responsibility exists outside and anterior to the law. Parental responsibility involves duties owed by the parent, not just to the court. First and foremost, and even more importantly, parental responsibility involves duties owed by each parent to the child. Now, we say with great respect to the argument against us that it is inconceivable that the Mental Capacity Act would have legislated for a complete decision-making framework, abrogated the relevance of parental responsibility in this context, and said nothing about it. It simply is not possible to imagine that Parliament would have created such a regime without clear and express language. The second flaw in advancing its central submission, that the MCA provides a complete decision-making framework, is that the appellant is driven to contend that in this context, parental responsibility no longer survives in 2018, quote, whatever the common law may once have provided. But that statement is unsupported by logic, because the appellant's contention properly analysed in its printed case does not appear to be founded on the proposition that the MCA of itself was responsible for altering the common law or statutory regime under the Children Act. See the phrase in paragraph 4 of the case, the position in light of the relevant domestic statutes and in particular the MCA 2005 and international standards. And finally, the appellant appears to accept that Gillick undoubtedly set down the parameters of parental responsibility in respect of confinement for care and treatment in 1985. That is accepted at paragraph 65 of the appellant's case. The common law was, to use its word, undoubtedly reflected in line with Gillick competence principles in the exercise of parental responsibility over 16 and 17-year-olds. So, with those concessions and with the centrality of his case premised upon the MCA providing a complete decision-making regime, we submit that the claimant, the appellant, creates an insuperable obstacle to the success of its case. Well, I now turn to our 7 core propositions. First of all, as a matter of domestic common law and under the Children Act 1989, it was at the time of the House of Lords decision in Gillick within the ambit of a parent's lawful exercise of parental responsibility to authorise the confinement and or confinement for care and treatment of their child where he or she is 16 to 17 and not Gillick competent to consent. So that was the common law at the time of Gillick. Second proposition, in terms of the common law, Gillick has not been superseded so as to restrict the scope of the exercise of parental responsibility as articulated in that case. Third proposition, the enactment of the...
Sorry, could you just repeat the second one? Because I was
Yes.
busy writing down your first.
Yes, my lady, yes. In terms of the common law, Gillick has not been superseded so as to restrict the scope of the exercise of parental responsibility as articulated in Gillick. Now, that's purely in terms of the common law, without, at that stage, taking into account international instruments or anything else cited by the appellant.
And are you going to take us to passages in Gillick that make it crystal clear that in their lordship's view, parental responsibility, or it would have been rights in those terms, included the right to lock up your 17-year-old daughters?
Well, I'm going to do my best to show you...
Because that was not the ratio of the case. The ratio was that...
where Gillick takes us to.
Yeah.
Third proposition, the enactment of the MCA and or its enactment taken in conjunction with the Children Act 1989 has not affected the common law regulating the scope of exercise of parental responsibility over 16 or 17-year-olds in this context. That's saying no more than that the MCA clearly does not abrogate parental responsibility. There are a lot of reasons for making that submission. Fourth proposition, no other domestic statute has affected the common law in that respect. So what we do in the second proposition is take the common law as articulated in Gillick, basically say there's no case since Gillick that supersedes what was said in Gillick. Then thirdly, because you have to salami slice the submissions made by the appellant in order to arrive at the right result. The fourth submission is that no other domestic statute has affected the common law in that respect either, because apart from looking at the MCA and the Children Act, the appellant then invites consideration of Section 9, Section 8, I think it is, of the FLRA, and Section 131 of the Mental Health Act. They're the only other two statutes that are mentioned. So they don't affect the common law either. The fifth proposition is that the Children Act ensures respect for private and family life under Article 8, whilst at the same time offering protections for the interests of 16 to 17-year-old children. It's a point made by Sir James a few minutes ago. The sixth proposition is that the European Convention on Human Rights does not affect the common law position either. In fact, it supports it. That's Nielsen, Koniarski, D, I think it is. So you have to go through each of these exclusionary processes in order to see what is left to build on the common law. And finally, we say that international instruments do not affect the common law position, and the common law is not impermissibly discriminatory. But by that stage, if you've got to stage 6 without international instruments, it's extremely unlikely that international instruments could affect the logic of our analysis. So let me turn to Gillick, our first proposition. And I was hoping to be able to take this proposition relatively briefly because, as I have said, the appellant concedes, see its case at paragraph 65, that at the time that Gillick was decided, parental responsibility extended to a parent being able to authorise the confinement of a child aged 16 to 17. So we are met immediately with a concession as to what the common law was in 1985. As we read
Which paragraph?
Paragraph 65, my lady. It's
Yes.
memory stick 3127. I think it might be,
Well, no doubt Mr. Setright will tell us whether that's a correct reading of that.
3127. The Court of Appeal held...
Yes,
in
it's
the
all right,
context-
I've just read it.
Yeah.
No doubt everybody else has too.
Yeah. So we read...
I'm questioning that.
Well, I understand the lady's question. All I'm saying is that's the concession as we have read it. But the first point to make about Gillick and parental responsibility generally is that it is axiomatic from the statutory definition in the Children Act, Section 3, read with Section 105, that the exercise of parental responsibility applies to children aged 16 to 17, or should I say includes children aged 16 to 17, because...
Some responsibilities quite clearly do.
Exactly.
There's no doubt about that.
Now,
Particularly the right to consent to a child's marriage.
Yeah. But it's very broadly expressed, of course, Section 3, and it doesn't in itself distinguish between age groups. So you have to find any limitation somewhere else.
Goes back to the common law.
Yeah.
It says all the rights, blah-de-blah-de-blah-de-blah,
Yeah.
which at law.
Absolutely.
Goes back to the common law.
Yeah, no, I accept that. The relative vulnerability of children aged 16 to 17 is, however, well recognised in domestic and international law. G. and Southwark, your ladyship's judgment in G. and Southwark. It's reflected in the international instruments as well, that 16 and 17-year-olds should not be treated as if they were adults. And there is no warrant in our submission in limiting the definition of parental responsibility differently according to whether or not a child is under 16 or is over 16 years of age before you even get to Gillick. The pre-Gillick position was dealt with by the Court of Appeal at paragraph 55 and by reference to the case of Hewer and Bryant as including, and I quote, the power physically to control the infant's movements, the ability to restrict the liberty of the person, and more generally, physical control or physical possession, resulting in, quote, a personal power physically to control the infant until the years of discretion.
Until the years of discretion.
Exactly.
The years of discretion were?
Well, my lady, I'm not sure.
No, that was a technical term at common law, years of discretion.
Well, your ladyship can no doubt clarify.
I think it was 12 for girls and 14 for boys.
But the age of the years of discretion changed.
Older for girls than for boys.
No, well, it's one way right. It's one for one and one for the other. Yes, it could be the other way around. Yeah.
Yes, but of course the years of discretion.
Anyway, it was under 16, whatever it was.
Evolved
That's
over
the only relevant point.
Yeah. And it's true to say also the Court of Appeal noted with approval that the legal right of a parent to custody was a dwindling right. I accept that.
That's right.
But when we move to Gillick, and this is really the key point, the rationale or the ratio of Gillick in terms of the decision it was called upon to reach was by reference to a child, a minor, having sufficient understanding and intelligence to make the decision. So we find that, for example, at page 188A to C in the judgment of Lord Scarman, speech of Lord Scarman, cited at paragraph 19 of our case. The modern law governing parental rights and a child's capacity to make his own decisions was considered in Regina against D. The House must, in my opinion, must, in my view, be understood as having in that case accepted that, save where statute otherwise provides, a minor's capacity to make his or her own decision depends upon the minor having sufficient understanding and intelligence to make the decision and is not to be determined by reference to any judicially fixed age limit. So whatever the age of discretion, the years of discretion finished at for respectively males and female children, a minor by the time of Gillick was up to the age of 18. And as Lord Scarman also pointed out at page 185D to E, memory stick page 197, the principle is that parental right or power of control of the person and property of his child exists primarily to enable the parent to discharge his duty of maintenance, protection and education until he reaches such an age as to be able to look after himself and to make his own decisions. And the Court of Appeal noted in particular the dicta of Lord Scarman at page 186, memory stick 198, that the parental right yields to a child's right to make his own decisions when he reaches a sufficient understanding and intelligence to be capable of making up his own mind on the matter requiring decision. And so we say that the Court of Appeal was right at paragraph 83, memory stick page 3262, to make clear that the Gillick approach to competence of a child was to be determined by reference to the characteristic development trajectory of some, not to be determined by reference to the characteristic development trajectory of some hypothetical, typical, or normal child, whatever those expressions might be understood as meaning. They had to be by reference to the child and not by reference to some average chronological age. And so, on the Gillick approach, we submit that neither chronological age nor societal norms concerning the average child of any age can determine the scope of parental responsibility. Different children will have different levels of understanding and maturity, and therefore, correlatively, the scope of parental responsibility may be the same in relation to two children of different chronological ages, but the same level of maturity and understanding. And we submit that's the context of Gillick, that's the rationale of Gillick. It's true that in Gillick, the children were under 16, the child was under 16, but that is its central rationale, and that is why the appellant makes what we submit to be the inevitable concession that it does. So if that's the position at Gillick, the question is, in terms of purely looking at the case law, has anything in the case law changed since Gillick? And we respectfully submit that the Court of Appeal correctly analysed the common law cases post-Gillick in its judgment between paragraphs 86 and 112. Essentially, it observed that nothing had disturbed in those cases the principles to be derived from Gillick. In its case, the appellant does not take issue with the Court of Appeal's analysis of the post-common law Gillick position, but instead, see paragraph 65 of its case, the appellant, far from submitting that Gillick was wrongly decided, submits that it has in some fashion been superseded. And that's really been the leitmotif of my learned friend Mr. Setright's submissions today. And it is, we submit, important to unravel exactly what the appellant is saying. Under this head of argument, the common law, absent international instruments and so forth, we are solely concerned with the content of the pre-existing common law. But the appellant's main submissions focus on a different issue, that is to say, the supposed abrogation of the common law by the MCA. So although purporting in his case to present an argument based upon this, under this heading, supersession of the MCA, a supersession of the common law, the appellant is actually focusing on the regime introduced by the MCA. And that's demonstrated if you look at paragraph 65, the opening sentence, in which it's suggested that the common law was not frozen as a result of Gillick, and that this is said to be shown in light in particular of the passage of the MCA in 2005, and also the trend in international human rights norms. So having accepted that Gillick articulated the common law as we submit it plainly did, and accepted that, the appellant then says logically, well, the common law isn't frozen in 1985, and no doubt it isn't frozen, but then comes back to the MCA. And really, it's the MCA plus international human rights norms that underpin the argument. But that proposition depends for its success on an entirely separate proposition, which is whether or not the enactment of the MCA abrogated pre-existing common law. But aside from referring back to the enactment of the MCA, see the appellant's case at paragraph 65.1, 65.2, and 65.3, the only separate argument advanced for Gillick having been superseded are that the common law, quote, can respond to changing circumstances, which is true as an abstract proposition, but not true, we say, in a context where Parliament has repeatedly legislated and has not, cumulatively or singly, abrogated parental responsibility. In fact, it's a disguised submission that adds nothing, since the so-called changing circumstances are necessarily a referring back to the enactment of the MCA. And we say, if the MCA has not abrogated pre-existing common law, then that pre-existing common law is not abrogated and remains the common law. The main case for suggesting that the common law can respond to changing circumstances is Montgomery and Lancashire Health Authority. That's at volume 5, tab 48 of the authorities. But that case really is nothing to the point. That was a case about negligence and reasonable foreseeability, and whether or not it was, in the modern age, necessary for a patient to raise a specific question with the doctor before a doctor could be held liable in negligence. It was essentially a factual question. It wasn't changing the common law of negligence. What is alleged here, by contrast, is that there is a change in the common law relating to parental responsibility by nothing more than invoking the Mental Capacity Act regime. What connects the common law in Gillick, we say, to the common law today is the fact that its rationale, that's to say the Gillick rationale, is as applicable to 16 or 17-year-olds lacking Gillick competence as it is to under 16-year-olds. And yet the appellant accepts that in respect of under 16-year-olds, the Gillick competence law remains as part of the common law. And in that respect, that's to say the seamless transition, really, between 15, 16, 17, we cite at paragraph 16 of our case the judgment of Mr. Justice Kean in the present case relating to the time that D was under 16. And I wonder if I could just ask the court to read that. It's paragraphs 55 to 64, and it's cited in our case at paragraph 16.
What does he mean by paragraph 62?
Well, I take that to be implicit acceptance of Sir James's submission that professional advice was important in the validity of parental consent.
What I'm trying to get my head round is the idea that there is parental responsibility which allows the parents to make these arrangements without prior sanction or immediately ex post facto sanction, and yet you have a very helpful account of Mr. Justice Kean here, which says the position might be different, which suggests that it's not within the zone of parental responsibility if the parents were acting contrary to medical advice.
Well, what I wanted to
nobody suggests, forgive me, Mr. Clerk, I'm not making myself clear. Nobody suggests that even if parents are acting within the zone of parental responsibility, their actions are not subject to an ex post facto control in the best interests of the children. That is the law and has been the law for a very long time. So it's what he means by saying the position might well be different if the parents weren't basically acting in the best interest of their children. Does he mean then there will be an ex post facto control, but there always is an ex post facto control, a possibility, or does he mean that parental responsibility is restricted? I was trying to get at this with Sir James as well.
I think it's a reference back to paragraph 61. I can see no reasons or justifications for denying the parents that role or permitting the state to interfere in D's life. But that might not be the case if the parents were not...
So he's referring to the intervention of the court rather
Yes.
than the content of parental responsibility.
That's as I read it.
Thank you.
As I read it. But the importance of those paragraphs, they really leap from the page in terms of what we were talking about earlier, the balancing of the Article 8 rights. It's no part of our case that, absent a valid parental consent, parental responsibility could just be exercised by parental fiat. There has to be a valid parental consent, and there have to be mechanisms for protection of arbitrariness. We accept that.
Well, what are those protections?
Well, I'm going to come to those
Oh,
later.
good. Thank you.
I will come to those.
That would be very helpful.
But the point we make here is that provided there is a valid parental consent, and remember here that we're talking about cases where for want of a better phrase, the health professionals are in agreement with the parents about what are in the best interests of the child. So we're not talking about where there's a dispute. I appreciate questions arise, well, how do you get to court, etc. But we're talking about cases where we have a Section 20 regime with all the attendant safeguards and where there are court corrective mechanisms if there isn't a valid parental consent, as well as duties on the local authority to, first of all, take the wishes of the child into account at the beginning, constant reviews. So it's in that context that this position arises.
Well, I appreciate that, Mr. Gordon, which is why I come back to what is the fundamental content of parental responsibility.
Yes.
Because we are looking at it in the context of a very particular case and a very particular situation
Yes.
in which everybody agrees that what is being done for and with D is in his best interests, etc., etc. Everybody has been working to that end. But we have to consider the cases where that isn't the case.
Absolutely.
We have to consider what the content of parental responsibility is, where there's no medical advice, it's not in the best interest of the child, there's no local authority oversight. Parent choosing to lock up their child under the stairs.
Well,
To take an example from a
this
well-known
appeal-
work of fiction.
this appeal concerns a Section 20 set of safeguards.
Yes, but we cannot say that parental responsibility contains the right of a parent to confine, and I apologise for using the words lock up, but that's what it means, a child of 16 or 17 who lacks the capacity to make the decision for himself, unless and until somebody comes along to prevent it. That's what you're asking us to say the law is. Now, it may very well be that it is the law, but I have to test it
Well,
against...
my lady, what we say is that the common law begins and ends with Gillick competence. And what you're being asked to do is change the common law because of perceived isolated deficiencies in contexts which are not this case. And we say that is not a permissible exercise. And the central pivot of the case rests upon the proposition, as I hope I've demonstrated already, the illogical proposition, given its incompleteness, that the Mental Capacity Act regime is a comprehensive decision-making framework which applies to all 16 and 17-year-olds, irrespective of parental responsibility. Now, whether the law should be changed, whether there are imperfections in the law, we say, with great respect to the way the case is now put, that what this court cannot do is fill in any gaps that there are. But what we do say is that there will obviously be positive obligations on the state outside the framework of the current protections which exist in the present context. And it's the present context with which this appeal, of course, is concerned. But whatever the imperfections, the rationale of Gillick is not age-related. It is sense and maturity related, and it's only in the context of 16 and 17-year-olds that this court's being asked to intervene. So it's not only a change in the common law, but it's a selective change in the common law. So this is really the point. It's not an issue in these proceedings that Mr. Justice Kean decided the case correctly when D was under 16. He was plainly deploying a test of Gillick competence. And it's not easy to see why the relevant principles applying to the exercise of parental responsibility in relation to 15-year-old Gillick incompetent children should not apply equally to vulnerable 16 and 17-year-old children.
I think it was being said by Mr. Wolfe that there would be no child who would lack Gillick competence and not, in fact, be suffering from an impairment within the Mental Capacity Act.
Well, I'm not sure that's right, because the Gillick competence test is framed in a completely different way. I'm not saying that there are huge gulfs in the context of care and treatment, but the test is not impairment. The test is sufficient judgment, I can't remember, but sufficient maturity, basically. So it's not the same test at all. And that's the other point, that the imposition of an MCA, what is a functional and not a legal test, it's a point I'm going to come to later. But the Mental Capacity Act does not lay down a legal test of capacity. It lays down an immunization from liability from people acting within its regime. But it does not lay down a legal test of capacity. And legal capacity under the Gillick framework is expressed in the way that Gillick expressed it. There are lots of reasons why the MCA cannot be said to provide a complete decision-making regime. So that will bring me to my third proposition, hopefully tomorrow. But I've done the first two. In other words, purely looked at in isolation. What was the common law at the time that Gillick was decided, conceded? Has it changed in terms of the case law? No. What is the rationale for dividing up children into these categories? And tomorrow I'll come, if I may, to the Mental Capacity Act regime.
Thank you. Thank you very much indeed, Mr. Gordon, and to everybody. The court will now adjourn. I look forward to hearing from you further at 10:30 tomorrow morning.